Lord, I turn then to my response to various Eateries appeal.
Yeah.
And my learned friend applies with permission in relation to the per premises or per insured location argument in relation to aggregation. And as your lordships will have heard, VE say the judge was wrong not to conclude that aggregation, or more precisely the SBIL, operates on a per premises basis. And I think she starts by saying, well, the judge was wrong really to use the SBIL language as the starting point. And we respectfully suggest that that's an unpromising start for a criticism of the judge, starting with the contractual language. And we certainly say that is where one should start this analysis, and indeed, ultimately, one could draw a line at that point as well. And if your lordship just pulls up the SBIL language, that it's SB, supplemental bundle, tab 1, page 33, definition 105.
Yeah.
One starts by underlining the obvious point that, of course, there is no reference there to per premises or, consistent with this policy or the language of this policy, insured locations. What there is reference to is single occurrence. And of course, we accept a single occurrence may on some occasions simply affect one premises. But similarly, as a matter of language, there's no reason why it can't affect multiple premises. So, for example, I come back to this, prevention of access over all of central London as a result of police action would have the same effect of closing down multiple premises within that radius. And there's simply no restriction in the aggregating provision by reference to premises. That's not a neutral point. It's really the answer. The aggregating provision doesn't do so. Now, Lord,
it's focusing on the occurrence.
Yes.
Not on the premises, and not on the effect, if you like.
Precisely.
What it's basically saying is, if there is one occurrence, then you only get X.
Exactly.
1X, you don't get 10X in this example.
Exactly, Lord. And of course, I accept that on some occasions an occurrence will only affect one set of premises, maybe the typical situation. But there's nothing which cuts it down. We say you get more support of it when you follow through the language if one looks at the definition of business interruption loss. Now, your lordship's looked at this for a slightly different purpose, which my learned friend's taken you to. But if I can just work you through the definitions, one will see that business interruption loss, which is at page 23 of the definitions, definition 9, is defined as reduction in turnover, and I'd just say etc., solely in relation, and then there's a specific point in relation to stock and business interruption loss. If one then goes to reduction in turnover on page 32, one sees that that's defined by reference to the amount by which the turnover during the indemnity period falls short of the standard turnover, less any cost normally payable out of the turnover as may be cease or be reduced during the indemnity period as a consequence of the covered event. And then if we go to the definition of turnover, which is definition 116 at page 35, we see turnover means the money paid or payable to the insured for goods sold and or services rendered in the course of the insured's business at the insured locations. And if we look at insured locations, that's definition on page 27, definition 49. That's expressly referred to as all locations and sites owned and occupied or utilised by the insured, or for which the insured has assumed responsibility for the purpose of the insured's business, etc.
Yeah.
And if we look at the definition of insured business, that's on page 27 as well. At the top, definition 46 means the business undertaken by the insured described in item 1. And we've seen item 1 definition, chain of Italian restaurants. So the definition of SBIL is by reference to the business as a whole. And we
Yeah.
say that is, again, a firm pointer away from aggregation on a per premises basis. And indeed, one could take perhaps a simple example. If you have two restaurants, one restaurant is affected by a prevention of access, and so it has to cancel the bookings.
Mm.
You would also be looking at whether any of those bookings are transferred to another restaurant, with a view to understanding whether the business as a whole has suffered a loss or not. Hence, was looking at this as an overall bird's eye view from the perspective of the policyholder who is running the business as a whole.
Well, you see there might be circumstances in which if they've got two restaurants in close proximity in a particular part of London, and one of them has to close, if it's for whatever reason, if one of them is, if it's a very popular business, then the other restaurant will be absolutely full of people.
Yes.
So the overall loss may be smaller.
It's simply underlining the point that one's looking here from a perspective of the business as a whole, not by reference to calculation of individual restaurants or units. I mean, it may be there are individual accounts which help that exercise, but in terms of the final calculation and in terms of analysing the single business interruption loss, the focus is on the loss to the business as a whole, not to the loss of individual locations of the business. We do say that's also supported by the retention, which is in the schedule, tab 5, same bundle, page 83. And my learned friend sought to emphasise the last bit of that clause, referring to single property losses and single business interruption losses combined, as suggesting it was consistent with there being multiple single business interruption losses. But what it ignores with respect is the beginning of the clause, where the insured has made a claim for a single property loss and or a, for relevant purposes, single business interruption loss, affecting one or more locations. And that's the key point, that there is a claim for a single business interruption loss affecting one or more insured locations. It is envisaging the possibility, expressly envisaging the possibility of multiple locations. Now, my Lord, we do make the point which my learned friend addressed in relation to the policy on other occasions referring either to insured locations or similar terms in terms of when it meant to in relation to capital additions or the supply chain. There's a simple point to be made and there's a slightly more involved point. The simple point that one makes here is that irrespective of how these specific provisions tie in with the rest of the policy, this is an example of the policy using the language one would expect, using the defined terms of the policy that one would expect, where that is relevant. So it uses, in the case of the capital additions, the term insured location. And so that's the first point. That's sort of the overall point that the policy does what you expect. If it means to do something by location, it says so. And that reinforces the point that I've already made in terms of the ordinary meaning of the SBIL clause. The slightly longer answer, just to deal very briefly with my learned friend's point, that there is an oddity about this clause, about the capital additions clause, because is it adding something extra? Are you getting more than you would do under the £2.5 million single business interruption loss, because it's adding £2.5 million? Lord, the short answer, we say, is it ignores that £2.5 million is a sublimit, it's an inner limit, which covers all losses, including material damage and business interruption loss. Sorry, I should so and Lord, one sees that on page 81. It's headed sublimits. the sublimits detailed below will operate as part of the limit of liability applicable to a single property loss and or single business interruption loss. So saying that you have added on 2.5 million per individual location tells you nothing about whether there is a lower single business interruption loss for an investigation of some sort which has a lower SBIL. It's simply the inner limit for those claims. You cannot have more than 2.5 million for both single property loss and or single business interruption loss. Now, I said, look, in a way, I don't really need to go there because my simpler point is simply that the policy does use the language of insured location when it intends to do so. My learned friend also...
I suppose the question might arise whether if you get a straightforward answer from simply looking at the definition and chasing through the definitions, going very much further than that starts the territory of minute analysis of the policy which the Supreme Court said you shouldn't do.
Well, I very much endorse that, my Lord. Obviously, having to meet a minute analysis, I do so. But, Lord, yes, my starting point is very firmly that the judge was entirely right to start where he did, and indeed was entitled to end where he did. The judge, in fact, went slightly further and said any other conclusion would be slightly bizarre, and gave the example of the lower limits in relation to, I think, the 250,000.
I mean, obviously, if the exercise of looking at the definition doesn't give you an answer, or if you conclude it's neutral, then you've got to go somewhere else.
Yes. Well, obviously, Lord, if you don't need to hear from me any further, I'm content. But I would just, to be fair to my own friend, to cover off the points that.
Speaking for myself, it seems to me you're drilling down, if I can put it that way, into the definition of turnover. Seems to answer the point, even if no other argument answered it. But you've actually got about 5 arguments.
Yes, I mean,
Yes,
I mean, I'm happy to try and deal with them very quickly. I mean, because for example, in a way, they all make the same point. I can deal with them quickly, and they are in writing. I mean, the covered events point that my learned friend made.
yeah.
In my submission, it is simply with respect a bad one because it ignores expressly what the judge found. The judge found, and this is at tab 18 of the supplemental bundle, paragraph 72. The judge expressly found that prevention of access was only one covered event. So my learned friend was trying to take you to examples of discovery of a bomb. Well, it might just affect one premises, but the judge made an express finding that the covered event under 12, and one can see this if your lordships just look at it, was not to be regarded as the number of advices or actions, but rather than the number multiplied by was to be regarded as the number of advices and actions, rather than the number multiplied by the number of the insured locations to which those advices or actions related. And that's the conclusion on the bottom 4 lines, considering the prevention of access. Now, the judge had reached a different conclusion in relation to enforced closure, which he did consider was a covered event by reference to each premises.
Yeah.
But the point, that's not appealed, and it makes no sense to say that the aggregation is premises specific when not even the covered events are premises specific on the judge's findings. I mean, we would say in any event, even if they were all premises specific, so what? This is an aggregation clause. But it just underlines the fact that there's a lack of reality in what is said. I mean, the arguments on factual matrix in terms of schedules going to the, in terms of making up the premium, well, of course they would. That's how you calculate the premium. You need to know the business that you're insuring, and that involves having the figures for each of the units. That tells you nothing about how you decide to aggregate the losses, nor does the declaration of values by reference to items 1 and items 2. At the point my old friend relies in her skeleton, I think less orally. Again, the most that does is a grouping together of certain locations. It's certainly not separating them out, and even if it did, is not suggesting that that's relevant for limits. And I think your lordship has the point in relation to Corbyn and King, which is the focus on that was there is a composite policy. It's right that there are other arguments as well. If your lordship looks at the wording there, you'll see that the wording isn't by reference to single occurrence. I think it's by reference to claim.
Yeah.
And indeed, there was the wording that the judge appears to have focused on in the part that my learned friend took you to was very much the linking of the business to a location, to a premises.
Yeah.
Now, whether that was a correct construction or not, one might respectfully question as to whether that was the natural reading of that clause. But that appears to be what the judge focused on. Again, that is entirely absent in this case. The more general point that each insured will be each set of premises may be affected differently. Well, that's correct. That may support a conclusion which can already be made on the question of construction. That's simply not available here. It's simply a reason for saying why you might want to consider a per premises limit or per premises aggregation. It's not an answer for telling you what the policy actually says. And in terms of the arguments in relation to the level of indemnity, well, with respect, they go nowhere. I mean, these are commercial decisions as to what limits of indemnity you take. And one should note, these are not insignificant limits. I mean, in the context of disease, it was £2.5 million. I think my learned friend may have suggested that this was a standard limit across these policies. If that was the intention, that's not quite right. There are different limits for these different policies. They're not all 2.5 million. Just to be clear, they vary, as you would have thought, depending on the cover that is bought in any individual case. So one can take very little from it.
Well, quite a few of the listed events or covered events in clause 2.3 are ones where things like infestation, which is a sort of classic. You know, the health inspector turns up, closes down the restaurant for 2 weeks. You'd be hard pressed to have a BI claim for 2.5 million arising out of that. So I mean, you know, the point I'm trying to make is that these things cut both ways, really. I mean, obviously, if you're right, then the premium must have been set according to what the aggregate limit was. And if the insured had wanted more insurance, they could and should have asked for it. They'd had to pay a lot more premium.
Yes. But of course, it's a bit more, we would say, there's obviously an element of sophistication beyond that, in the sense that it's not just the limit, overall limit, it's the limit for individual types of risk. So there are certain types of risk where in reality, that the chance of them occurring is perhaps regarded as so low that in fact it doesn't cost much more to have 48 million or 2.5 million. Things like disease, where even prior to the pandemic, one might assume have been regarded as a different category of risk, a different approach may be taken. So one has to assume that there may be different.
Well, in the test case, the Arch case, we did. My recollection was that we inquired about the history of this clause or these clauses, and there was some. I don't know if there was any formal evidence. It was certainly suggested that some of them go back to the 1930s. And to things like tuberculosis.
Well, certainly if one looks at the list
outbreaks of tuberculosis or diphtheria,
and well, certainly if one looks at some of the diseases,
rather than pandemics, if I can put it that way.
I mean, it's certainly right. If one looks at the list of notifiable diseases, some of them do look rather 19th century in terms of what they are, and as often one probably has had a building up of lists and of terms. Over time. But so I wouldn't dissent from your lordship's overall position that it doesn't assist much. I would suggest that the judge's approach was probably still right to say that if, insofar as there is a relevant cross-check, the relevant cross-check is the fact that when it comes to insuring clause 2. Perhaps I'll just take your lordship back to it, page 76 of the supplemental bundle. That's the with the various limits on. The way you have the clause 2.1, business interruption, property damage, 48 million odd, or insuring clause 2.3, the first 5 items with the 48 million figure, that is indicative that there must have been an assumption that this was applying cross premises rather than just one premises.
Yeah.
And one might say, well, why doesn't it work the other way around for the lower figures? And the answer is that it's exactly what I just said, that there are certain risks which will impose either higher premiums or greater risk, which one seeks to control. So it's about controlling down risk rather than controlling up. Anyway, I don't want to say too much more about it, other than to say that these are commercially negotiated figures, which don't, certainly don't move one away from the natural meaning of the SBIL clause.
Yeah, one has to have well in mind that this policy was, I mean, I don't know if this was a renewal of a previous policy, it probably was, but whether it was or wasn't, it was renewed in September 2019 before anybody had any whiff of COVID, let alone that it was going to be a global pandemic. So yes. You have to judge, in a sense, to judge the construction against the position as it was at the time, not looking at it now and thinking, my goodness me, they didn't have enough insurance cover.
Well, your Lordship's point is of course well made, that there is a danger looking back and saying this is a policy which ends up not giving me full cover. And of course that's the wrong way round. Sometimes it may be a proper test to ask, is this policy not providing obvious cover that I would expect it to give? But if one asks that question, as your Lordship correctly says, at the inception of this policy, the answer would be, well, it does give, and it gives meaningful cover for notifiable disease. It's £2.5 million. This is, it's not a shop being closed for a day. Whether it was adequate is a separate question. And of course, going forward, insurers will obviously want to consider, as will insurers, much more carefully the extent to which they are, the level of cover they seek, and indeed the premium that's sought for that cover. Lord, those are my submissions on the per premises appeal. That leaves the 2 applications for permission to appeal. The first one is the argument that there won't always be a single business interruption loss, and the judge was wrong to find that there would be. And various Eateries cases is essentially that the better interpretation of the policy is that it limits aggregated losses to the limits of liability per SBIL, the 2.5 million in this case being the higher limit, but unaggregated claims to the total value. And one only has to say that to understand how bizarre, with respect, the submission is. Why would parties agree to a lower limit where there are multiple losses which aggregate, but a higher limit where there is no aggregation of this assumption? And no attempt's been explained why the parties would have agreed to such counterintuitive limits. Now, I appreciate that on my appeal, I've been saying one has to focus on the words and not what parties intended, but it's a useful cross-check before one starts looking at the wording as to whether the wording is even open to such an argument. And the reason, of course, it's bizarre is that the very logic of an aggregated SBIL is that what would otherwise be considered several losses are aggregated as though they were one. That's the very purpose. And so we do say that there is an oddity here which isn't explained at the outset, and in my submission simply can't be explained. No commercial parties would reach such an agreement, whether you're an insured or an insurer. There is simply no logic in that approach. Now, my learned friends relies on the distinction between business interruption loss and single business interruption loss. And the essential part of the submission is, well, the coverage is in relation to business interruption loss, and accordingly she is entitled to business interruption loss unless it aggregates. But the point goes nowhere because, as your lordships have seen, single business interruption loss is defined by reference to loss that arises in connection with a single occurrence. So if, as the judge rightly accepted, and I come back to this, there's always going to be a single business interruption loss, then the fact that the insuring provisions refer to business interruption loss and not single business interruption loss makes no difference. So that raises the question, is there a possibility of there being a case where there is no single business interruption loss? And in our submission, there isn't. We made the point in our submissions that at the time that we made those written submissions, there'd never been an example given of what it would be. I think my learned friend today suggested the cases of disease before the 16th of March. But with respect, that's the point. If they don't aggregate to each other, then it is, as Mr. Keeley was explaining, they would be individual occurrences, individual single occurrences. Yeah. And one suspects the confusion here has arisen, perhaps through the word aggregating. Because whilst it's of course right that the SBIL is an aggregating provision, there doesn't in fact need to be any additional aggregation. It's simply saying that if it is in connection with a single occurrence, it is to be treated as that business interruption loss is to be treated as a single business interruption loss. And we can be confident that there will always be an occurrence for the purpose of the policy, because if we look at the definition of the policy and go to covered events, which is on page supplemental bundle, page 23, definition 17, we see covered event means the events as described in insuring clauses 2.1, 2.2, 2.3 or 2.4. So for our purposes, it's covering each of our clauses is being defined as an event, well, it's covered event and being described as an event. And as we've been repeatedly told, and as the judge found in Stonegate and as the Supreme Court has found, event and occurrence are synonymous. And so if there is a event in each of the insuring clauses, there will always be at least a single occurrence. And given that loss has to be proximately caused by the relevant covered event, that loss must necessarily satisfy the looser test of being in connection with the single occurrence. I mean, put another way, any losses which are caused by an occurrence which results in cover under the insuring clauses will necessarily be in connection with the single occurrence for the purposes of the SBIL. And my learned friend took you to Stonegate and Greg's to try and suggest there was a different approach. I think your lordship's already seen them. My suggestion is there's no difference or inconsistency at all. And just for your lordship's note, this was a point expressly put to the judge in the consequentials hearing, where he made clear that he did not consider that there was any inconsistency because he was dealing with different points. So it's in Supplemental Bundle 2, tab 21.
Yeah.
Page 628. And it's the two elements of it to be looked at together, perhaps. If your lordships can just look at, starting at page 18, from line 20, and this is first dealing with the question of the declarations, up to the following page, internal page 22, line 9.
Yeah, well, that was the point that I raised with Mr. Mulcahy. Between 15 and 18 on page 21, where the judge says in terms, I haven't decided anything about position of losses pre-16th of March.
Greg's judgment was simply dealing with something
Which is
completely
why
different.
this point of it, if it has any merit to it at all, doesn't really arise in this case.
Look, obviously it's an application made, and indeed, I think the point your lordship's made is exactly the one that the judge then picks up
Yeah.
at page 642.
Yeah, I mean, one has a hint of the submission you just made at page 20, line 3, where the judge says, my view is if there's a covered event, there will also be at least one SBIL. In other words, he's got in mind it's an occurrence, it's an event. They equate.
Page 642.
642, yeah.
And this is just dealing with permission to appeal, but again, it just sets out in brief terms the judge's position on this, starting on internal page 74.
Yeah, a line.
Or just, I should say, page 73, line 24 is I think where it starts.
Mm-hmm.
And just going over to the middle of 75.
Yeah.
I mean, your lordship was quite right to say, certainly our submission is that one doesn't need to get to these points of detail. It's really answered by the wording. But my lord, if one does then go into the detail, it really all supports the original conclusion that we submit is apparent from the wording itself. Look, can I turn then to the second ground on which the various eateries seek permission to appeal, and that's the suggestion that the argument that the judge was wrong in holding that there were not separate single occurrences for the purpose of single business interruption loss when government measures were renewed, immaterially changed or relaxed. And your lordships have, I think, now seen some of the extracts from the chronology which provide a bit of an indication of how it works. So it's probably right to say most of them aren't really renewals, they are reviews in this context. And the judge's conclusion was set out at paragraph 101 of the judgment. I think my learned friend took you to it, and also at paragraph 86 of the Greg's judgment. We say there are 2 points to bear in mind here when one starts looking at this question. The first is that because this is an aggregating question, we're back to the question of the informed observer in the position of the policyholder. The second is, and it's related to it being an aggregating provision, is that one is looking for, I come back to it, the meaningful explanation, the significant cause for what has occurred. And we say quite simply that the judge was right to say that if one is looking at this from the perspective of a policyholder, a decision simply to continue following a review or to renew a measure that's already in place without any material alteration doesn't provide any useful or meaningful explanation, because without more, it isn't changing the substance of the original decision to introduce that measure. As the judge says, it simply continues the status quo. It's not so much a question of can it be an occurrence? It's a question of, for the purpose of the aggregating question, is it a relevant occurrence for the purposes of a single business interruption loss? Or is it the occurrence with which it is most closely connected? And one can test it in a number of ways. If one has a water main and the council closes the road for the day, it doesn't quite know how long it's going to take to repair the road, so it closes it for the day. The next day comes and it's not been repaired, so they keep the road closed, and so on and not so on for a week or 2 weeks. If one is looking for the meaningful explanation, it is the original decision to close. The fact that it has continued because it's not been repaired isn't, from the policyholder's perspective, a particularly interesting question.
No.
The question would be, what event, has there been an event? Yes. And indeed, for present purposes, I accept one might say there are other events later on. But what's the relevant event for the person whose road's been closed for a week from the mortar main? It's the original closure of the road, the decision to close it on the first day, which has then continued in place for the rest of the week. And we do say that Silversea does provide some help on this. I think my Lord the Chancellor suggested, well, Silversea was a case where it all reflected back to 9/11, and there was essentially one warning. My submission that it is of course right that it reflected back to the defining event, as Mr. Justice Tomlinson called it. But of course, these weren't the same travel warnings over the 6-month period.
No.
They were travel warnings based on the latest intelligence and the latest risks to US nationals overseas. Now, the decision to aggregate it back to the defining event of 9/11 is entirely understandable, but it'd be wrong to suggest that all of those warnings were simply a repetition or based on exactly the same information as 9/11.
No.
They were based on updates, but none of that altered the fact that, in my language, the highly relevant, the defining event continued to be the original event itself, the 9/11 attacks. And that, again, is the analogy that we draw here. Again, conscious that the facts are not identical, but it's the process that we say can be adopted in this case, in which the judge was perfectly entitled to adopt as the guide of saying what makes the difference or doesn't make the difference. My learned friend also focused on the question of relaxing a measure and whether relaxing a measure should be regarded as a different event or a meaningful event. But we say that relaxing a measure is simply continuing the measure, but to a lesser degree. And so, for example, if one takes an example of a road which is closed, which prevents access to a shop. On the first day, it's completely closed. On the second day, let's say that there'd been some gas explosion. On the second day, the police say, well, actually, we can let a few people in now, and they let the shop owners into their shops. On the third day, they let pedestrians in, and then on the fourth day, they repair the road and vehicles go in. There would have been a prevention of access over those 4 days, and it will have been a prevention of access of lessening degree. But the relevant occurrence is the decision to close off. There isn't more prevention of access when you relax it.
No.
It's the opposite. And indeed, the judge put it well, we would respectfully say, when he said that the effect of relaxing a government restriction isn't actually to cause the policyholder to suffer any loss in addition. If anything, it's going to reduce the loss that the policyholder was suffering previously. We also say there's a tension here with what my learned friend is suggesting in this context of what amounts to the relevant single occurrence which connects to the loss, and the argument that was made and indeed accepted by the judge in relation to causation. No, because if your lordships turn to tab 15 of the core bundle, the e-judgment, page 258, paragraph 70, and this is the judge's analysis, having rejected my argument in relation to the scope of the prevention of access and the enforced closure clauses. The judge then addresses, well, what is the scope of cover provided by those clauses? And he answers that question in paragraph 70. Can I just invite your lordships just to look at that quickly? Now, I entirely recognise that's a discussion about causation rather than the aggregating effect of SBIL. But if anything, the position of SBIL ought to be stronger. Here, the judge is talking about the need for connection in relation to proximate causation. And the judge is finding, indeed, following my learned friend's invitation, that an enforced closure or prevention of access continues to have proximate cause until it is materially changed. Or it continues whilst it is, to use the word, in substance the same. Given that the test for the SBIL is simply whether the loss is in connection with, the scope for aggregating event ought to be wider than it is for disclosure, for proximate causation in the context of causation. So it underlines that there is an inconsistency, we say, in the approach that's being urged in this context. And when one stands back overall and considers, well, what is the correct approach? What the judge has done, which is to focus on the position of the policyholder, looking at the issue and considering how the loss should connect with any particular single occurrence, then the answer, we say, is clear. It's the one the judge gave, namely it connects to the original decision or restriction, and that only changes. There's only a new relevant aggregating single occurrence when there is an addition to that restriction. If it simply continues the same, that's maintaining the status quo. If you're relaxing the position, if anything, it's reducing the amount of loss. It's not stopping that loss from being connected with the original decision. So
once the restrictions are lifted altogether, there may be continuing loss because people are not prevented from going to restaurants anymore, but they may not feel safe or comfortable in doing so. And so in respect of that period, would that aggregate to the original restriction, or would that be a new loss?
Well, in terms of the covered events for prevention of access and enforced closure, my initial answer would be that it's unlikely that loss, that what we might call public hesitancy, would be a result of the prevention of access.
I mean, it might be within disease, though.
Precisely,
and the disease clause, wouldn't it?
Exactly, and so
it's the same position in effect as the claim before the 16th of March.
yes, and so Lord, in relation to the disease clause, I think the position that at trial was that we accepted that the insured could prove, if the insured could prove continuing loss within the maximum indemnity period, then they can prove the loss. What you couldn't do was assume that there would be such loss or that it would be collected with the original disease. with the original occurrences.
Yes, but it wouldn't be connected, or it wouldn't have a causal relationship to the closure in March, which is the aggregating occurrence in respect of disease claims, you say.
Well, my lord, the answer is possibly not. It would depend on what the public hesitancy was. If one ties the public hesitancy back to the fact that the government acted, so if one has two scenarios, if one has the Sweden scenario, where there was always a public hesitancy simply from the fact of the disease, there may be in the UK an additional hesitancy, which is not just from the disease, but the way that the government reacted to it. So Lord, I appreciate that's maybe a bit more of a complicated answer, but say it's not necessarily right that it doesn't relate back to the government action, but I obviously can see the argument that it might not do. Because the test is causal connection, is the causal connection or in connection with, all that's required is a relatively weak causal link between it. And if one is able to establish a weak causal link between the continued hesitancy and the actions that were taken, then that may be sufficient. But if in fact there is no such connection on the evidence, then I accept that it wouldn't connect.
But at all events, we're not asked to deal with the situation. I mean, I agree with my with Lord Justice Mayles that it's quite an interesting question actually.
And Lord,
we don't have to decide it.
And my Lord, I'm reminded, which obviously is relevant for these purposes, is that is on 16th of March, and this is relevant for prevention of access as well. The advice was obviously social distancing, so that and that being regarded as being part of the prevention of access, telling people to keep their distance, etc. And that, of course, could be said to have had an ongoing effect. So, and then it would relate back to the original guidance of keeping 2 meters, keep away from people. So, I certainly it can become more complicated, and obviously, so that would be for stage 2. Perhaps it's not a black and white answer, but if the question is simply, will there come a time when things are no longer connected to the original measure if it's taken away? Of course, I accept that.
So I simply contrasting relaxation of measures, where I can see the argument that after relaxation, it still connects back to the original restriction, and a complete suspension, where, subject to the point you make, it's rather harder to make that connection.
Yes, I mean, I certainly accept the factual point that once it's gone, there is likely to be less of a connection, but what I wouldn't want to say is that there might never be a connection, in particular when one considers that some of the restrictions, or the government restrictions, related to advice, which may have changed the way that people act for a longer period than they actually were enforced.
Yeah.
Well, I'm reminded these problems wouldn't arise if we aggregated Wuhan. Lord, I mean, on a serious note in relation to that, there is an element where we do say that one of the consequences of not focusing on the right aggregating events is one does cause a lot more issues. I mean, your Lordship will have seen what's the position about government action. It becomes a much more complicated picture. Now, that of course is not an answer to saying, well, that there is, it should aggregate back to an earlier point, but it is perhaps just a reminder that of the consequences of not finding an aggregating event, in that it actually makes it much more complicated for insureds and insurers in terms of how to actually allocate losses to the various heads, to the covered events, and to carry out the aggregation process. Lord, I think those were the submissions I had on ground 4. So unless your Lordship have anything further.
No, thank you very much, Mr. Dodd. Yes.
My Lords, I'll respond on the 3 grounds of appeal, just dealing first of all with per premises aggregation. I have 3 points. You were taken to the definition of reduction in turnover, and it was said that the focus is on the loss to the business as a whole, not to the loss of individual locations or to individual locations of the business. I just wanted to draw your attention to a part of the definition of reduction in turnover that my learned friend didn't refer you to. If we look at the supplemental bundle, volume 1, 132, just to note that at the end of that definition, it states if the insured's business is conducted in departments, the independent trading results of which can be ascertained, the reduction in turnover will apply separately for each department affected by the covered event. And that points to a department-specific measure of reduction in turnover and thus of business interruption loss. And we would say if business interruption loss can be department-specific, it can also be premises-specific. It can be isolated out, as indeed happens when the estimate for annual insured profit is declared to insurers and forms the basis for the premium. And we would say it would seem to follow then that the SBIL could be department or premises specific. We would say premises specific too. So it's not an indivisible
That
whole.
point might be said to cut the other way, in that they identify departments.
But not premises. I take that point, my lord. But for what it's worth, it seems to be a pointer towards being able to break down. It's not one indivisible loss to the business. It can be broken down, we would say, naturally by premises.
Yeah.
My learned friend said about limits, that the 2.5 million, and we accept that that may differ from policy to policy, and it was said that that's not insignificant as a limit. Well, that's all a question of perspective. In the Stonegate case, there was a £2.5 million limit, the same as with VE, despite having 760 venues and a total value of nearly 2.5 billion. Now that is obviously colossally greater in terms of total value versus the SBIL limit, and we would say that that is something to just take into account in terms of whether the 2.5 million necessarily reflected it must apply across all premises collectively. And the final point, it's a short one, is that pre-pandemic, and clearly some of the diseases on the notifiable disease list had the capacity to be wider in scope, whether epidemic or pandemic. But what, and this formed part of the argument in the FCA test case, what parties probably had in contemplation at that stage before we had a global pandemic would have been things like enforced closure due to Legionnaire's disease, for example, or food poisoning, which was more likely to be premises specific and may therefore provide the commercial rationale for having a limit of 2.5 million applicable on a per premises basis.
Yeah.
So that's all I was going to say about per premises aggregation. Just one short point on always one SBIL. My learned friend took you to definition 17, which is the definition of covered event at page 23 of the policy supplemental bundle, as meaning the events described in insuring clause 2.1, 2.2, 2.3 or 2.4. If we go back to 2.4, we can see that that is business interruption cyber event. And so when Allianz is saying any losses which are caused by an occurrence which results in cover under the insuring clause will necessarily be in connection with the Luso test. And in their skeleton they say event equals occurrence. The fact that cyber event is a covered event, it uses event in both senses, cyber event, and comes within the definition of covered event, doesn't mean that it aggregates as an event, as an occurrence. It doesn't, because as we've seen, it's by reference to an originating cause. So one can't just equate the use of event in relation to coverage with meaning event in relation to aggregation. And then my final point in relation to the issue of relaxations was really just to give you a reference to in the agreed chronology to the decision that lifted lockdown 1. It's a core bundle 12, page 159. And you'll see for the 23rd of June 2020, Prime Minister's statement announcing further relaxations of the lockdown restrictions, including reopening of restaurants and pubs, and then stated, as you'll see on the right-hand side, that step 3 can be implemented as planned on the 4th of July. And then at the bottom paragraph, from the 4th of July, your household will be able to meet with one other household at a time, including staying over indoors or outdoors, etc. You must remain socially distant from anyone outside your household, and then there's the continuing to meet in a garden or park in a group of 6 people. And we can see, if we go over the page to 160, on the 25th of June 2020, statement that the 26th of March regulations were reviewed and continued. There's no specific public document confirming that the 26th of March regulations were reviewed on or shortly before the 25th of June. But the Prime Minister's speech on the 23rd of June confirmed, with reference to the 5 tests, that restaurants, among other things, would reopen from the 4th of July 2020. It's considered to be implicit in that statement that the parties agree that the review was carried out by the 25th of June as required by the 26th of March regulations. And then you'll see at the 4th of July the revocation of the 26th of March regulations and their replacement with the 4th of July regulations, allowing these venues, amongst others, to reopen, provided they complied with various guidance. And we would rely on that decision on or about the 23rd of June as a separate single occurrence, which would then mean lockdown 1 is one single occurrence, and then the lifting of lockdown 1 is another single occurrence, giving a further limit, assuming, of course, that there is aggregation. My Lords, those were my points in reply, unless I can assist further.
Thank you very much. Thank you very much for finishing well within time. And only remains to thank both sides, and I emphasise, because I know that although you have been oral advocates, you've received considerable assistance from your juniors and your solicitors. It's always a team effort, especially in a case like this. So we've been tremendously assisted by some excellent submissions on both sides, whoever wins or loses. And we'll have to go away now and decide for ourselves the answer. We're not going to give judgment on the turn, you won't be surprised to hear. We will obviously do our best to get you a judgment as soon as we can. I suspect it's unlikely to be this side of Christmas. You will get it in the usual way in draft for corrections or in relation to typographical errors and the like, not for inviting the court to revisit matters or to make further submissions. Please pay attention to the terms of the embargo at the head of the judgment. There have been occasions, as you probably know, when the embargo has been breached recently, and certainly in the Court of Appeal we're concerned about that. So if we want to go on having this convenient system of draft judgments, we have to all make sure that those provisions of the embargo are complied with. Apart from that, thank you very much. And when the time comes, have a very good vacation.
All rise.